Good morning, everyone. Thank you for joining me here today. My name is Cherish Dela Cruz, and I am the owner and founder of Dela Cruz Law, which is located in Buckhead in Atlanta, Georgia. And I'm also licensed to practice law in Florida. Thank you so much for taking time out of your busy schedule to join us today. Feel free to ask any questions in the chat box. I want this session to be as interactive as possible. And I'd love to hear any questions that you may have, any concerns, or things that are going through your mind when you're thinking about estate planning. Now, in this presentation, we're going to give you an overview of the estate planning process. And we're going to help you think about, key things that you should consider when thinking about your estate plan. I know that with COVID and unfortunately with all of the upheaval we've had in the past year, that COVID has really brought to light the importance of planning for your estate. Unfortunately, I've had clients who've passed away from COVID, and I have friends and family whose members have been in the hospital as a result of COVID. And definitely it is a scary, scary time. And I think, people don't like to think about what if I get sick? But COVID really brought this into light and the importance of having an estate plan. So in this presentation, I want to just outline a little bit about what is going to happen. Really, this is an estate planning basics. People are intimidated by the word estate planning. Everyone has an estate if you own something. This could be a car, it could be a house, it could be properties, it could be bank accounts and life insurance. In this presentation, we're going to give you an overview of the estate planning process and help you identify key decisions that you will need to make in preparing your estate plan. We'll discuss how to create a plan for your family, your assets, and any type of emergencies. Also, we're going to briefly talk about small business owners as well too, because I do have a lot of small business owner clients and what that means for planning. And finally, we're going to help you understand what the next steps in the process are. So welcome everyone. Thanks for joining me here today. We're just happy to have you here. And really, I think education about the estate planning process is key, because with education, you are empowered to make good decisions. Death and disability are not fun topics, but if you are educated and you are starting to think about these difficult conversations that you may need to have with your family, your loved ones, or your business partners, it's important to plan that piece of it. So essentially, planning for your family. I myself have 3 wonderful young children. And when I was doing my estate plan, I thought about all of the things that I would want for them if I was not around. But no matter what your family looks like, it could be somebody who you're in a long-term relationship, somebody that you love, or if you're single, it could be your friends and family that you want to take care of in the event that something happens to you. Or you could be the sole provider in your family, the stable one that has everything, the stable individual who has everything together. But no matter what your family looks like, if you're married, you're single, you're a parent or otherwise, it's important to have a plan in place so that your wishes can be carried out in the event that something happens to you. Now, let's start talking about kids. As I mentioned before, I have 3 wonderful children who are unfortunately virtual schooling right now. The past year has been a little bit of a challenge, but I also want to make sure that in the event that something happens to me, that they're taken care of. Now, the reason that I went into estate planning goes deeper than, um, and was the result of losing a loved one. My aunt Mimi Bell, right here, she's the one in the yellow dress, and she got diagnosed with a rare form of appendix cancer, and this, this, she was like a second mother to me. Um, she helped raise me in Toronto, Canada. And she just loved to take care of us. She didn't have any children of her own, so she always treated me like her daughter. Um, so there she is. She was also a nurse. Um, and so, just a little bit about her background. When she got diagnosed with appendix cancer, I was the only individual in the family who was a lawyer. And because she thought of me as her daughter, she wanted me to be the executor. And of course, I happily agreed to be the executor. I was a securities and compliance lawyer working in house, which means I was working for a company. I knew a little bit about estate planning, but I didn't really understand the significance of what that really meant. So somebody had recommended an attorney in Racine, Wisconsin, so that it was a general practitioner. Both of my aunts and I went up there, and we went to the attorney's office. We walked in. I remember it clearly. It was a beautiful sunny day. And it was nice and warm compared to, for being in Racine, Wisconsin. And we walked out. He asked us like two or three questions, asked us a little bit about what was going out, but we literally walked out in 20 minutes with a signed will. Nothing else, no other ancillary documents concerning her health or powers of attorney so that I could handle her affairs when she got really sick. There was no type of healthcare power of attorney so that we could discuss end of life issues. So I literally walked out with a will with my aunt. She signed the document, and we thought everything was fine, that was enough. And unfortunately, it wasn't enough. It truly wasn't. It caused a lot of complications in our family, um, things that should have gone to individuals through a non probate process, like her hard earned retirement accounts, were subject to creditors because we didn't know. I didn't know, even though I was a lawyer. Um, and so there she is here in the hospital. And, we have a very close knit family. And unfortunately, all of that stress and that tension caused a lot of conflict in our family. People were fighting over things that they didn't necessarily need to fight over. Discussions that we should have had with our family weren't had because we didn't know. We didn't know what this was going to look like. And this is my continuing why. This is my wonderful children below. But I think about them, and I think about all of the loved ones, and how they would be impacted. So when you're thinking about kids who are under 18, you need, as a parent, to think about who is going to take care of them. Because if you are a single parent, it's of the utmost importance, because you don't want to have the court decide who is going to take care of the child that you love. And unfortunately, this happens a lot. I used to work for DFACS, and I would see single parents who didn't have a will or didn't have expressed wishes have the court decide who would take care of their child. So it's really, really, really important to choose that. Um, and then I want you to think about, can you trust that the state will take into consideration all the things that you would naturally think about? Like my children before, I showed you the picture, they have certain and different qualities. My son has ADHD. And so his needs are going to be different from his sister's needs because he needs additional help. The court doesn't know all of those things. And to have somebody else other than yourself appoint that individual, you know, only you as a parent know those intricacies. Um, Unfortunately, I see what happens too when the courts make the decision. And do you want your family members to be fighting over who would take care of your child? Unfortunately, I see this happen more often than not. Um, when family members are fighting as to who is going to be the best person to take care of your child until they turn 18. So I also want you to think about and answer these questions when selecting a guardian. Um, is this person? So the first question I want you to think about is this person going to be able to handle raising a child until they are 18? Being a parent, if you are a parent, it's tough. And it can be challenging, and it's the most rewarding job. But there, if you pick your sister, is she going to be able to handle raising your children? Um, I myself have picked my sister, and she knows that if something were to happen to my husband and myself, that she would be the individual taking care of them. But, we discussed what would happen in that event and how I would want them to be raised. And, other questions that you might want to also ask yourself is, does my children know, respect, and love this person? And yes, my kids love and respect their Tita Lara. Also think about, is this person responsible to take care of your child? Do they have either the experience, maturity, and wisdom to take care of your child? Another thing that you need to think about is this person healthy and physically capable of taking care of your children? Sometimes people who are my age, I'm in my 40s, my mid 40s, will, think about their parents. But one thing that you need to ask yourself is, will they be able to run around with your child? Or do they have the capability? Or is there a possibility that this older parent or older individual might not be around? Unfortunately, I've had cases where grandmothers have had to take care of children who are young, and who are 1 or 2 years old because their child passed away. And that can be a difficult situation, so that you have somebody who's in their 70 raising a 2-year old. And is that feasible? Another important thing to consider is, does this person share my beliefs and values? What are the values that I want to pass on to my child? And then also, logistically, does this person have space in their house? If you are thinking about a guardian who lives in New York, in Manhattan, will the guardian come and live in Georgia if you're there? If your child is there, or will they, move to New York? That's a fundamental shift for the child. And then, does this person live near my children's other family and friends? Now, one thing I also want you to think about is, if you have a child that has special needs, um, you, I've worked a lot with families, wonderful families who have children with special needs, and their lifestyle is, can be different. So, it may mean additional doctor's appointments. It may mean trying to qualify for government benefits, and having access to special programs for their children. Um, and so you want to, as a parent with special needs child, you want to make sure that you create that detailed plan, which is in the best interest of your child in the event that you are not there. You also want to ensure that if they're receiving medical and government benefits, that they are able to um, receive those benefits in the event that you are gone. So, just generally speaking, you cannot leave those assets to the special needs child, or they may be disqualified in getting certain benefits. Now, I just saw that here that there's a question and answer. Um, and I'll definitely get to that in terms of immigration and considering an estate planning. But thank you for that question. You also want to make sure that you are, if you are an older adult. So I have a client whose daughter is my age. She's a special needs child. The mother is older. She's in her mid 70s, approaching 80. And I know one of her biggest concerns is making sure that her daughter is provided for and that she can still be eligible, that someone will physically take care of her. Or if her family members can't take care of her, if she has enough money and access to government benefits so that she can be eligible for it. And I meet a lot with baby boomer parents who have special needs children, and they're concerned about that. Okay. And so minors in finances. One big thing that I have seen and that I have come across are parents who list their minor children as beneficiaries on their accounts. And this creates havoc actually in the administration of the estate. Prior to me getting into estate planning, I did the same thing. I named my daughter Emma as beneficiary of my estate after my husband. What I didn't realize was that if you do that a conservatorship has to be established, which means more court intervention because a minor child can't inherit any assets. Now, here in Georgia, this means, and Florida, somebody under 18. So a big thing is don't list your minor children or grandchildren as beneficiaries on your accounts, or you'll have to go through a conservatorship, which is a long, expensive, and cumbersome process. So for this reason, it's essential that you do the planning and you either name somebody like a trustee to handle the money for you until your child is able to. I know that in doing my own planning with my children, one thing that we did consider, my husband and I, is that we didn't want them to act like they had just won the lottery. We wanted to instill the values of hard work, of continuing hard work, and not have access to money until we really felt like they would be capable and that they could use that money wisely and use it in terms of a legacy so that it can continue on and support them in the event that my husband and I aren't there. So the person who is managing your estate financially needs to also be able to provide for your children. So you want to make sure that you've carefully thought that person out. Now, this is where a testamentary trust comes in. Now, I want you to think about a testamentary trust as something where, it's a will. So a will actually has to go through probate court. And probate court, or probate, the process of probating is taking that will and bringing it so that the court can supervise that entire process. So when you have minor children, or even I've seen grandparents do this, and I've done this for my clients who do have grandchildren. They've set up what we call a testamentary trust. If you have specific instructions regarding how or when you wish your assets to be distributed, you can set up a trust as part of your will. With a testamentary trust, you can specify the terms as to when you want your children or grandchildren to receive their inheritance. So what I've seen some of my clients do, they say, okay, let's create a trust for my minor children. You know, little Bobby Joe is only a year old. And I don't know what I want for him, but I know that I don't think he will be responsible enough to handle this money until he turns 30. But I also want to provide for him and incentivize him to, work hard in school and also work hard in his life. And I want to, set up certain mile markers or thresholds or ages as to when he can get that money. For example, some children want to wait until, or some parents want to wait until their child graduates from college to provide some money from the trust. Of course, that trust can also be used for health, education, maintenance, and support, which means that money can be provided to the guardian, which is a person who is physically taking care of your children, so that, they can provide for things like backpacks, school trips, food, maybe additional expenses, medical expenses. But some of the parents and the grandparents, they want to incentivize the children and have them finish college or law school. And so they'll create those provisions in a trust. So a trustee is somebody who's going to manage all of those assets and make sure that the trust is handled in a way that the children or whoever is the beneficiary, and beneficiary really just means somebody who is going to receive the assets. So let's say a beneficiary would be my children, and I want my children to receive the assets at, whatever money I have in my life insurance, and after all of my property is sold, I want them to receive it for, starting a business or finishing college, but I want to structure it so that they don't spend all of the money at one time. Now, adult children, even if you're a parent of adult children, I have seen, this is the scenario that I always get. I have the professional child or the small business owner come in, and they will come to me and, their parents don't have their estate plan. Or their parents come to me and they want to make sure that they fairly and equally distribute the assets to their adult children. You know what? Unfortunately, it's so unfortunate that sometimes family members and children will fight once the parents are gone. And, it could be a result of, just past hardships or the children don't get along. But, all of this a lot of it can be handled with open communication and also a detailed estate plan. What I like to do, and when I'm working with older adults, parents who are in their 70s or 80s, is really talk about and dive into the intricacies of the family and whether there are any issues that I need to be aware of so that I can create a detailed estate plan. And then also, what we do is when we're incorporating their wishes, we detail out that if there is a potential for disagreement among family members, why the parents are setting up let's say, for example, a trust, that they want to preserve family harmony, that they want to distribute the assets equally among the children, that, that they don't have a preference for one child or another. So this is a way of making sure that your children who may disagree, it allows them to look back at these words, the words that you have created, and to try to preserve that harmony. Now, sometimes as we all know, there are complicated family situations, where, there may be instances of, different couples, or, children, the parents may not necessarily like the spouse. And here at our law firm, we deal with that all the time. Sometimes it may be blended families. Sometimes it might be blended families, extended families, um, non-legal marriages, just partnerships. And we handle all of that. But what we do is we dive into the intricacies of all of that. And one of the ways that we conquer that is really by creating a revocable living trust. And I want you to think of a revocable living trust as a bucket. It's a bucket that you create during your lifetime. And you want to have certain situations or details or instructions to your trustee. And the trustee is the person who manages that bucket. So in certain situations, it will be, okay, I create a trust during my lifetime. I want my children to have these assets after I pass away, but I want to make sure that my husband, Justin, gets some of those assets while I'm living so that I can support my children. But I also want to ensure that, I have ultimately provided for that children. And so what that might mean is creating a condition in that trust to say that if Justin were to get remarried, that he needs to execute a valid prenuptial agreement before he gets married, or he won't have access to the assets of the trust. So those are certain conditions that we can address, complicated family situations, or, incentivizing children who may, who may otherwise need it. And so saying, okay, if my son, Aiden, I want him to complete college, he won't get the trust assets until he completes college or finishes his degree, or has a job or a technical trade where he's self-sufficient enough to be an independent contributing member of society. So in complicated family situations, you can have a trust which details anything and everything that you want in there. And the great thing also about a trust is you avoid probate. What I have been seeing in the Georgia probate courts lately are a lot of estranged families that have to get notified. Maybe the brother or the sister hasn't spoken to the mom and dad in 20 years. And mom and dad pass away, and they have to notify brother and sister because it's a court supervised process. And part of that court supervised process requires notifying all of the potential heirs. And that may mean the estranged brother or sister. And what I've seen it play out is, and this can bring up a lot of emotional baggage that has been around. And so probate can become a complicated and messy process. So, I've been seeing that a lot in the past year, and just being aware of that and making an informed choice. Now, one thing as you're starting as the estate planning process is thinking about your assets. What kind of assets do you have? Do you have a condo? Do you have a house, which is called real property, which means, there's a deed associated with that? Or do you have a non-probate asset, which is like a bank account? And a bank account, has a beneficiary designation, or do you have investment accounts? And then also, once you've considered the people in your life who will inherit your assets, The next step is to understand how these are passed to your beneficiaries. And remember, again, beneficiaries are the people who stand to essentially benefit from you passing away. So this could be your spouse, this could be your children, this could be your parents, it could be your best friend. Um, and really what you need to do is to create a list of all of your assets. This includes all of your financial accounts, real estate, business, and valuable possessions. One thing that you may also want to consider is having adequate life insurance. I've seen situations you never want to be the family that is the GoFundMe family. Um, it it is hard enough to lose someone, um, but to try to find money to pay for the funeral expenses, to pay for the cremation services, all while you're grieving. I've seen it in several instances. And you might just want to consider getting some life insurance. Um, and it's also an efficient way to transfer wealth, to pay for any last minute life expenses through life insurance. You can also set up a trust with that as well. Now, another thing that is part and a critical component is planning for medical contingencies. What this means is essentially, you know, if you were to get diagnosed with COVID and you are an individual, what are the kind of choices and who can speak on your behalf in the event that you can't speak for yourself? In Georgia, we call that the Advanced Healthcare Directive. In Florida, it's, you know, the medical power of attorney, but it's someone to speak on your behalf. Who do you want that person to be? And then also, you know, fundamentally asking, after you choose that person, can that person make hard decisions for you? Are they emotionally able to handle challenging situations? Because I've been in situations where, and then also communicating with them, because I've been in situations where, unfortunately, where I've had clients pass away and the mother didn't know what her organ donation beliefs were, and it wasn't expressed anywhere. And this was a young mother where she could have donated her organs, her heart, and everything to someone. And you know, her best friend was in the room, and her best friend knew that she wanted to be an organ donor, but the mother didn't. And so, you know, ultimately, when the organ donation team came, um, they weren't, even though her best friend had thought about it and had expressed it to her mom, the mother did not know that. And so her organs couldn't be ultimately donated. So, you know, consider doing the Advanced Healthcare Directive, or to make sure that someone is speaking on your behalf. And, you know, I've seen this play out in the last year in terms of COVID and, you know, being able to access medical information, but, you know, who you would want to speak on your behalf. And then, you know, of course, this is a challenging topic, but, you know, talking to your aging parents, you know, what are their wishes? Do they want to, um, die naturally? You know, do they want to, if they were in a vegetative state, you know, what are their choices? Or do they want to have every kind of life-saving measure? These are just planting the seeds. And then also the do not resuscitate. Um, you know, I know a lot of doctors will err on that side if they don't have any guidance. But if it's clear that you do not want to have you know, you want to have a DNR, and that your mother or your father, they don't want that, then when it's clearly spelled out, you as the healthcare agent can make that choice, that informed choice, with that knowledge. And then also, it makes your loved ones rest assured in your decision because it's clearly spelled out. That person will feel less guilt or less hurt knowing that information because they know it was explicitly from their loved ones. Now, another thing that you need to consider is determining who would be your financial power of attorney. Now, I want you to think of a financial power of attorney as a legal document that allows your person, so this is a trusted person that you choose, to take care of your financial affairs. Now, when they're taking care of your financial affairs, and I'm sure you've seen this with all of the new, with all of the privacy laws, but someone who can call your insurance company, who can pay your bills when needed, who can pay your mortgage, who can find out what the balances in your account are so that they can pay all of these bills for you. So, just designating that person, who would be the best person to do that? And do they know where to find all of your important information? You need somebody to pay for your bills, essentially, if the stock market's going down and you needed to reallocate all of your investments, talking to your financial advisor and handling other matters, financial matters on your behalf. Now, what about an executor? An executor is the individual that you trust and that you want to handle bringing the will to the courthouse and actually supervising the whole entire probate process. Sometimes the executor will hire somebody like an attorney like me to do that probate process, but it's somebody who can, perform the legal tasks to settle up your estate. Some of the responsibilities of being an executor are selling your property, paying creditors, reviewing medical records, and distributing your assets to others. So things that you need to consider are, is this person responsible? You want to make sure that you carefully make those decisions to choose the right executor. This is somebody, an executor should be somebody who can act responsibly on your behalf and who can communicate. The key here is communication with your beneficiaries. If there is mistrust, or if the parent chooses somebody who would not communicate with the other beneficiaries feel left out and they feel like the executor is hiding something. And essentially, you can name anyone as your executor. It could be your friend, but you should be able to be the one to make that choice. Sometimes people will choose a professional executor, somebody who's not related to the family, who's not the best friend, somebody who is emotionally not involved in that process. But it all depends on your situation. And so you have to consider the trust factor of who do you trust to play those key roles. One thing when you're thinking about executors or trustees, and trustees are the people who are going to manage the trust for your benefit, you may want to consider somebody who's going to be around longer than you and for a long period of time. So, maybe not choosing your parent who is, far older than you, or a best friend who is not in the best shape ever, or who doesn't have the best health. In our client estate planning process, we always choose two successor trustees. And the reason why we do this is we don't want to guess or get the court involved when we don't necessarily have to get them involved. So, it may be the spouse as the first trustee, and then if the spouse weren't around, maybe it's the best friend, and maybe after the best friend, if the best friend's not around, the professional fiduciary. But at least we've contemplated all types of situations as to who can be the executor. Now, location of the executor or the trustee generally doesn't matter. I mean, with everything as we've seen through the pandemic, a lot of things can be done virtually. Generally, when you're doing trust administration or probate administration, that can be done online. Some states are, like Florida, are moving to an online notarization process and witnessing process. So it all depends. And generally they will hire an attorney like me to handle that process. But once you've thought all of the things that, just these key considerations, and I don't want you to feel overwhelmed with this process, because really, essentially, this is just a general roadmap of the things that you should have in place. These are the basic foundational things that you should have in place. Really, it's just, estate planning is truly a gift for your loved ones. It's for you to have peace of mind that your loved ones, whether it's a significant other, whether it's your children, it could be your pets. I've set up pet trusts, even for my own dog. So making sure that those loved ones are taken care of, and that they have the means necessary to be provided for, and that it's done in the least stressful way as possible. So where do you begin? Once you've thought everything through, work with us. I offer a complimentary consultation. Just start planting the seeds of what it's going to be like. And, sometimes you'll have to update your estate plan as life circumstances happen. So you may be inheriting money, you may be getting divorced, you may be a widow now. Those are all the things that you need to consider. But the basic foundational things that you need are, essentially a will, a last will and testament, or a trust. Now, remember, the trust does not go through probate, and a will does go through probate, which means that it's court supervised. You want to make sure that you have a power of attorney, a financial power of attorney. Somebody, you're still alive at this point. It's somebody to take care of your assets in the event that you cannot take care of your financial assets, which means, paying your bills, paying your car note, paying the dog walker, just different things, financial things that you would normally do, but that because of some type of incapacity, either temporary or a long-term incapacity, you need somebody to handle those things for you. And definitely, I think this is, comes up a lot, is an advanced healthcare directive. Really, who is going to speak on your behalf in the event that you get sick? Who is going to make those medical decisions on your behalf? Because if you're incapacitated or if you're unconscious, you cannot speak for yourself. And the doctor does not know your wishes. So it's really, really important to have. And another thing, here in Georgia, we do have the Advanced Healthcare Directive, which allows you to choose a guardian. So that's somebody who you want to speak on your behalf if ever questioned in court as to who you would want. And the way that I've seen this happen is in terms of, mom and dad, they develop Alzheimer's or dementia. Children are fighting as to who is the better caretaker of mom and dad. The court is generally going to defer to who you have chosen as the adult parent. Now, the last thing is really just creating your will or trust is only the first step. It's your responsibility. And this is what I truly believe. And that's why I love developing relationships with my clients, is I want them to call me whenever they are having an issue, if they've lost a loved one. It's important to me to communicate, if they're going through a hard time, or if mom and dad have developed Alzheimer's or dementia and they need other resources. I have a wonderful, wonderful, extensive network that are great resources for you. But, just keeping us informed, keeping your attorney informed, whoever that may be, of your life circumstances. And so essentially, feel free to, don't try to do this yourself. I had this financial advisor call me yesterday. Yeah, there are great things and there are great technologies, but estate planning is truly a gift for your loved ones. I had a financial advisor call me yesterday, and he wanted his one of his clients who has millions of dollars worth of assets, wanted to use the Susie Orman revocable living trust package, and wanted to fund that trust, and wanted him to title his assets to the trust. And it, that could be wrought with mistakes. And you wouldn't necessarily see what those mistakes are, but your family would have to, or your loved ones would have to face those consequences. And those consequences may be tax consequences. They may be leaving people out unnecessarily so. And so in the end, you have to think about the cost benefit analysis. Yes, it's exactly like my situation with my aunt. It was cheap, it was inexpensive, it was $100 to go out with a will, but it wasn't worth the heartache and the conflict that it caused in my family because we didn't have a good estate planning attorney. So please, thank you again for joining us, and please reach out to us. And essentially this, concludes our time together, but here is my information. And I am going to ask, one of the questions was, how does estate planning work for professionals who are not US citizens, nor residents, but are on a long-term work visa? Would you recommend considering estate planning in those cases as well? Yes. Yes, you do not have to be a legal resident here or a citizen to have an estate plan. What it's doing is, the probate court is not checking your immigration status. The probate court isn't, what they're doing is they're directing how your assets are to be passed. It might be easier to have a trust-based plan in that case so that there isn't even any court intervention, or there could be planning done in terms of non-probate assets so that it can pass on to those individuals without that. But definitely, feel free to reach out to me. There's my contact information. My number is 770-687-8813, or, there's my email address, cherish@delacruz-law.com. I'm always, always, always willing to have a conversation. And these are just general complimentary conversations that we have. It really is my mission and it's my purpose to help those, because of my own personal experience. And thank you for joining me here today. And if you have any questions, please feel free to reach out. So one other question is, what is the biggest difference in a testamentary trust and an irrevocable trust? So in a testamentary trust, you have to go through probate court. So what that means is a testamentary trust will have to go through probate court, and the court is going to supervise it. So that means that the executor will take that and will, the court's going to say, it's going to notice all of the errors. It's going to notice all of the individuals who are entitled to get that notice. And then, there's notification to creditors. Now, an irrevocable trust or a regular, well, let's first start off with a regular trust. So regular trust, if everything, I want you to think of a trust as a bucket. And in that bucket, if that bucket has all of your assets and it's properly titled, you don't have to go to probate court. Assets will pass immediately. Now, probate court has been, in Georgia, taking like much, much longer because of COVID. So, I would say, when a probate would generally be 3 months, now it's taking 6 months. Sometimes it's taking longer. And then if you've got heirs that are going to dispute that, then that might even be longer. And then an irrevocable trust is you can't change any terms of the trust. It's there alone. You as the trustee, you have no legal ownership rights over it. People will set up irrevocable trusts for estate planning purposes, meaning they want to shield a certain amount of money away from taxes. And so that's one way of doing that. You need to get your own separate tax ID number for that. And that's a little bit more complicated to definitely set up. But are there any more questions? You can feel free to put them in the chat. But thank you, everyone. I appreciate it. And please feel free, again, to reach out to me. I'm always happy to answer any questions that you may have. But thanks for attending. Bye.